Gather round, dear people, let me tell you a tale of guns and men. It's probably bad I don't know more about Dylan. In 2008, the United States Supreme Court passed down a 5-4 ruling called DC v. Heller. Dick Heller was a special police officer for the District of Columbia. He was authorized to carry a gun at work. However, at home, due to the District of Columbia's laws, he had to disassemble this gun. So, I believe he did get into a bit of trouble over it and sued to have the law invalidated. The Supreme Court is not known for leaning in on Second Amendment questions, and this time they did. Effectively, what they came to the conclusion was that this regulation meant that DC had a total ban on handguns, and the 5 members of the court who struck down the law did not look favorably to this. And while this was being debated, Supreme Court observers kind of waited around. They wanted to see what right would be given to all Americans. Would every American be given a long arm? Would every American have the right to keep a pistol in their home? A right to a shotgun in their home? Would the case end up decided on narrower grounds than that? And what would it mean for everyone if DC was to have this law struck down? Now, with gun control, ever more in the conversation than not, it is, I think, important that we look back on this case 10 years ago and see what it accomplished and what it did not accomplish. Now, the decision was written by Justice Antonin Scalia, and it goes on for about 62 pages. In a 64-page decision, I can bring it up here and check, see if this goes down all the way to page 64. Actually, it goes down to page 67. In 67 pages. It goes down to the 67th page. Of the PDF. So let me give you a showing of this. 65, 66, 67, and there's our it is so ordered. It says a whole lot of things, but ended up not really meaning anything. So this is a bit more of a larger beef with Justice Scalia's work. He, like many lawyers, fancied himself a grammarian. He thought that by looking at the original text of things, you could figure out the meaning, which is fair and all. But he was desperately in need of an editor. That's how I'll put it. This decision did not have to be as long as it was. This decision can be summarized in a few pages. This decision was far too long. In order to understand the decision, we need to understand his judicial philosophy. His judicial philosophy is what is called originalism. Originalism is the idea that by looking at the exact text of the Constitution and then at the words written by the founders, the people who wrote the Constitution, we can figure out what the Constitution means. Now, I think this is a very flawed idea. A lot of the people who are doing this aren't grammarians. So the problems in the case begin pretty early on when he states, "We turn first to the meaning of the Second Amendment." Now, the Second Amendment begins with a phrase, and I'm paraphrasing here, "a well-regulated militia being necessary to the security of a free state." Now, here we have two parts. We have that there's a well-regulated militia, and that the militia is necessary to the security of a free state. So, before we get at anything about a right being protected, we have that there is a militia, and that the militia is necessary. And this is considered by Scalia anyways, a prefatory statement, just to give the initial meaning of the text. And, well, back in the olden days when this was written, states had militias on hand. They maintained them. So, in other words, the common interpretation of the Second Amendment that existed before this case was that it was constitutional for states to make and maintain militias, wherein, well, right now, well-regulated means well-trained. Well-trained militias to protect against the tyranny of a potentially large federal government. Now, Justice Scalia throws that all out. As I said, he's not really a grammarian, but he likes to think he is. Well, liked to think he was. I have to remind myself he's dead sometimes. He talks a lot about how the initial clause is just a preface. Essentially, it's only there to give a reason, but the reason does not limit the meat of the amendment, which, paraphrasing it, the right to keep and bear arms by the people shall not be infringed. So, we have two parts of this amendment. One that says that for the purpose of keeping a militia, the state, and then another that says the right to keep and bear arms by the people. So, I want to get my thoughts out on this. My thoughts out on this is, I think they could have very easily written the prefatory statement so as to not be there. No other amendment has a prefatory statement. The Fifth Amendment does not say, for the purpose of keeping people safe, we shall have due process. The First Amendment does not say, for the purpose of allowing people to reasonably live their lives, we shall have freedom of speech and freedom of religion. No, but the Second Amendment does say, for the purpose of keeping and maintaining a well-regulated militia. And this case threw that out. That basically no longer exists now. Justice Scalia essentially throws out those first two clauses of the Second Amendment. And this fact doesn't get reckoned with. Justice Scalia ignores it and then just goes with his own idea. His own idea being that the militia is every able-bodied man, and that means that every able-bodied man is able to have a gun regardless of the existence of a state militia. So what we see here is the word state militia being redefined to be every able-bodied man, which, I mean, realistically today, every able-bodied man and woman that would be able to fight in a militia has a right to own a gun. And to come to this conclusion, it took about 64 pages. Now, when I was drafting this, I put the meat of that into a single spaced page. Less, actually. It's why you don't trust historians with editing. Now, of course, there's a dissent to this. 5 justices decided for Heller, 4 wanted to decide for D.C., and Justice Stevens wrote the dissent. And the dissent points out that the scope of the right in the Second Amendment only really makes sense if it's a collective right to have guns and not an individual right. And to me that makes sense because of the prefatory clause. If you were going to guarantee the right to everyone in your country to have a firearm for lawful purposes and subject to the reasonable regulations and restrictions of the state, as all things are, then why preface it with a statement about militias? Even looking at how the amendment was drafted confuses the issue. While some states straight up put into their constitutions that people have a right to keep and bear arms, dissents tend to be where juicy details are. And we can look back at Supreme Court precedent, and in 1939 in U.S. v. Miller, it was decided by the Supreme Court that an 18-inch shotgun was not reasonable for the maintenance of a militia, and therefore does not fall under Second Amendment protections. So, if we're trying to think this through, the Supreme Court had previously decided 60 to 70 years back that you can only have guns that are reasonable for the maintenance of a militia. They did not define what the militia is. And fast forward to 2008. Supreme Court says, all right, well, we got our militia right here. The militia is everyone. Everyone is the militia. And as it turns out, some of the drafters didn't even agree with Justice Scalia's view. So why is this important? Well, when this case was decided, it was hailed as a champion case for originalism, because both the decision and the dissent used that legal philosophy. So the thinking kind of went, where the decision and the dissent uses that legal philosophy, it's a win for that legal philosophy. Now, I can kind of follow that. The problem was, the decision used sloppy originalism. Let's see. Yeah, a well-regarded conservative judge, Judge Posner, even referred to the decision as fake originalism. That's not the praise you want. You don't want to be fake, you want to be real. We have to get real, man. And at the time, the NRA declared that the decision had given Americans an individual right to possess guns. But that's not true if you read the decision. Because in the decision, Scalia also wrote that the right to possess guns is not unlimited. Well, I didn't mention it earlier. Scalia did go out of the way to say the decision does not harm the state's ability to stop felons, the mentally ill, the law's abilities to prevent firearms from being brought into a sensitive place like a school, or the state's ability to restrict gun sales. In other words, it didn't actually weaken gun laws in most of the United States. This, despite the fact that the nation's largest gun lobby is happy to try and convince people that they do in fact have a right to sell and buy guns, and that they have rights to guns they don't have rights to. Yeah! Lobbyists! Gotta love them. So, we have a decision that only really made unconstitutional the absolute prohibition to have a gun. And it gets celebrated as this huge opening up of gun laws. And as a result, that absolutist position has taken a hold of American conservative circles. Instead of resolving the culture war on guns, DC v. Heller inflamed it. And I still hold that this is what happens when historians think they're grammarians, which is why, if you do want a grammarian on the court, Mr. President, I am both a law student and a man possessing a literature degree. I'm basically a licensed grammarian. Call me. There's a lack of understanding of what this decision means in the popular reference. And we shouldn't let that stand. Also, my farts like this duck. See? Doesn't quack. Said last video, no quacking. That was kind of a quack.